woke up sound and strong this morning. A lot of questions on my mind. Is to you or is it
made by the managers, specifically Councillor Albert Sims, for the following reasons. Column 1, that Councillor Albert Sims is a counsel of record in the case Echo Bank Liberia Limited versus Austin Clark, which is the subject and one of the counts of the basis of the amended articles of impeachment against His Honor Justice Kabina M. Janet. Point. Count 12, including paragraph A to M of the articles of impeachment, alleges that the respondent, His Honor Justice Janet, issued a writ of certiorari, and in that particular case, the counsel for Echo Bank was Austin Clark, that was Albert Sims of the Sherman and Sherman Law Offices. Whose representation was against Austin Clark at the level of the court and also before the Supreme Court pending determination. It is the same Councillor Albert Sims and the Sherman and Sherman Law Offices.
Objection, Your Honor.
It is the same Councillor Albert Sims and the Sherman and Sherman Law Offices that are now representing on behalf of Austin Clark against Justice Janet in the impeachment trial before the Senate. Point. In substance, Councillor Albert Sims and the Sherman and Sherman Law Offices are conflicted, and therefore, they lack the legal and ethical standing to serve as legal counsels in these proceedings. Point. The counsel says that after the notation of parties' representations, he has a submission to be spread on the minutes of court and respectfully submit.
Councillor,
Yes, Your Honor.
a minute's permission.
That is an objection we have to Councillor Albert Sims, and we do not want to be the victims of waiver and laches.
No, I heard the submission you made in respect of Councillor King.
Yeah, we have about two submissions.
You said that you have another submission.
That's correct, Your Honor.
Is that objection in respect of another councillor?
No, sir.
What's the nature?
The nature of this,
Of the record.
of the record, sir. The nature of this is simple, Your Honor. Present, the impeachment proceeding one, in order to proceed, the numbers of jurors are yet to be made available to the team. And also, Your Honor, preemptorily, if we desire, if your honors will allow, the objection to Councillor Albert Sims from the Sherman Law Offices extends to one of the jurors, the senators in person of Councillor Barney Sherman of Grand Cape Mount County, who have been sworn as a juror in these proceedings. He is also conflicted, given of the fact of the Echo Bank case. Councillor Barney Sherman is the owner or co-owner of the Sherman Law Offices, and he is also the very lawyer who represented Echo Bank against Austin Clark, and to now be used and to now say that he is a juror in these impeachment proceedings to determine the facts in this case as a judge of the trial of facts. Your Honor, I think I need protection from the bar. Councillor,
Please.
one of the jurors in presence of Councillor Barney Sherman cannot sit as a juror, though you have sworn him. And the reason we're doing that is because we don't want to proceed, and you ask the question, Councillor, why you didn't raise it at a time when representations were being made. And then at the end of the day, we may suffer waiver in latches. And so, yes, Your Honor.
We are sworn in as a correctly stated, the jurors.
Correct.
Sit on a case. But if you look at the minutes of the last day's sitting, we have said that today we consider the motion requesting that I should recuse myself from the case. That's all?
Correct.
Now, my question is, which one do you think should come first? The recusal of this council, or the senator, or myself?
Your Honor, you first of all have to recognize the notation of the party's representation.
Correct.
Councillor Abelson's issue should be addressed first, then
Why?
you can subsequently. Because
If I do not have jurisdiction over this case, I should go ahead and pass on all of these issues?
the first thing is, Your Honor, before you...
No, answer me.
Your Honor, I think we need protection from the bar.
Councillors.
Nobody bothering you.
No, Councillor. If you take a seat here, you are a councillor. You are not a lawmaker.
Yes, Your Honor.
I will expect that you be quiet when the lawyer is talking.
I don't know what.
Otherwise, we would likely ask you to go out.
Yes, Your Honor. Apologies to the court.
Thank you, Your Honor.
Proceed, Council.
Your Honor, you are presiding, so you will determine. Since indeed, in fact,
In my
there are no
mind.
rules of impeachment yet.
In my
For us to
mind,
do.
Councillor,
Yes, Your Honor.
there is no reason why I should sit here and even decide this person is capable of coming in his case, this other person is not capable of coming in his case, if I myself don't have jurisdiction over his case.
Correct, Your Honor.
So, you have the right at subsequent time to be able to bring all of these issues that you're bringing up, we pass on them.
Thank you, Your Honor.
Should the need be for me to continue to sit here? So I think the first thing we should decide is whether or not the presiding officer himself has the authority to sit on his case.
Thank you, Your
All
Honor.
other issues should be decided subsequently.
No, Your Honor.
So I think you should hold your peace and hold your gun. Later on, you can know them and start.
Thank you, Your Honor.
All right? So let's see about representation today, and then proceed with the argument in the motion to recuse.
Yes, Your Honor, before we proceed, can we also get a copy of the minutes for the last proceeding?
Okay, let me address myself to that. Counselor, you know that if it's in the Supreme Court, you have already got the minutes, will pass upon it, you'll be part of the procedure I've had impeachment proceedings, but it has not risen to the level of a full-blown trial by the Senate. So I'm not even sure that the Secretary of the Senate, who is taking the minutes, can distribute the copies to us immediately after we come from here. So bear with him. I'm sure the other side does not have the copies of the minutes.
Not receive any returns or resistance from because they have not served us.
Returns to what?
Told the motion.
Which motion?
Motion for recusal.
Councillors, you're talking to the follow. If you continue that, I satisfy you. Okay, thank you. So how much time now do you want? Councillors?
Your Honor, let's say the resistance to the motion, and so we need an hour to peruse the resistance, and then we can proceed. You just serve us
You want,
an hour to peruse it, and we just come back.
you want an adjournment,
Correct? Your Honor?
1 hour more or less.
Correct.
So, what's the reaction?
Your Honor, we react to the request made by our friend consistent with Rule 63.22. First, if, and that's the standing rule that controls this proceeding, we even have the right to spread on the record our resistance, so it can be a defense for adjournment. So for us, absolutely we are opposed to the adjournment, even we could make our resistance on the record.
Councillor,
Your Honor.
you did not make your ruling on the minutes of court. You have a prepared resistance that you should have served on your colleagues. What does the law say?
Well, the law says it both ways. If there's a written motion under 16.16, which is not applicable, then we have to file a written resistance.
Yeah.
That's the law controlling the Supreme Court.
I'm talking service. How long does it take for you to serve before the hearing is had?
24 hours.
Did you do that?
Your Honor, this is a special proceeding.
Please sit down. Senators, I'd like to say something before we pass on this application. Under the law, when a motion is being considered, the jurors need not necessarily sit, because that's purely law. So, if you so wish, you may be excused. The only time that you are actually required to sit is when we are listening to the facts of the case. Motion is granted in law. And since you are not the trial of law, you are not actually required to be here. You may be excused if you so wish. Second thing I want to say is that the press, I think they should be correct with reporting of what we do here. It was in the papers, and I listened to the airwaves that today we are going to give ruling in a motion to recuse. But we have not even heard the motion to recuse. It's a process where you hear from this side, and make a determination. So I beg of you, press people, when you give these false and misleading information to the public, it creates anxiety. I was listening and said, well, where is this coming from? So the public is expecting, by virtue of that publication or that news item, that we are here today to make a ruling. No. We have not heard the motion. Therefore, we will not make the ruling today. After we hear the motion, then we set a time to make the ruling. As you can see, the motion was written. There is now a written resistance to the motion. There has to be a ruling that will take into consideration the points that have been addressed, both in the motion and in the resistance. So I implore you, press people, to always do the right thing. Again, this is a novelty in our society, to have a full-blown impeachment proceeding. From here, records will be set. Precedents. How we proceed tomorrow. So it's all of us business to do it the right way. Thank you. Senators, if you want to leave, you may leave. You have returns on them so that they will have the opportunity to read through it and then come back. As they address their own motion, they're supposed to be referring to their resistance. So how do you expect them to do that? On the first day, I told you people to be cautious to each other, to treat each other the same way we treat lawyers, treat each other in a courtroom. So let's keep to that. 1 hour on your side.
Correct.
1 hour. Okay, proceed.
Thank you.
Senators, let me tell you, this is not a Supreme Court, but since the impeachment proceeding conforms to the law, at the Supreme Court, a party has the right to take up to 2 hours for argument. That is to say, each side. So here, they requested for 1 hour on this side, 1 hour on this side. It is within their right. Therefore, grant them that right. Sir, Counsel.
Thank you, Mr. Chief Justice of the Supreme Court. The movement, in these proceedings cites for their legal reliance.
Counsel.
Yes, Your Honor.
But in this case, you prepare a written motion.
Yep. That's true, but Your Honor, the point is that because there are no rules that govern the proceeding, that's why we did. So we just think it out.
Well, so the law says we should go as much as possible with.
It's because of also the notice, Your Honor.
We allow it. Counsel.
Thank you, Your Honor. Counsel cites the following law citations in support of his legal argument. Abbott Dondo Ware versus the Republic of Liberia, FAR LLR, page 50. That includes syllables 1 to 5. Supreme Court's opinion. Matilda D. Richards versus Edwin U. McGill, 6 LLR, page 81, with specific reference to syllables 1, 2, and 3. Republic of Liberia versus H. Lafleur Hammer, FAR LLR, page 300. The Constitution of Liberia the 1986 Constitution, Article 43. And Article 90A. And also the Civil Procedure Law, Section 9.83, Liberal Code of Law Revised, Volume 1, Title 1. May it please, Your Honor. And Your Honor, we ask that you take judicial notice of other citations cited within the motion for recusal. The question before you today, Your Honor, is whether or not you, as the Chief Justice of the Republic of Liberia, can preside on this impeachment proceeding against Justice Kabina M. Janen if the facts and circumstances show that you are conflicted. And the answer to that question is, Mr. Chief Justice, you cannot preside over this matter for the following reasons. Your Honor, in my possession and attached with the motion for recusal is a Supreme Court judgment and ruling that you signed, which was questioned and is the subject of the petition for the impeachment proceedings of Justice Kabina M. Janen in the case before the Supreme Court decided March 10, 2017. Kabina M. Janen, represented by and through his attorney in fact, Yusuf D. Fofana, versus Mrs. Annie Constance and Brown, to be identified also of the City of Monrovia respondent motion to dismiss the appeal. In this case, Your Honor, you signed a judgment. Yes, Your Honor. No, I'm a trial lawyer. You signed a judgment heading the bench of the Supreme Court, and that judgment has been questioned by members of the House of Representatives that form one of the counts of the basis of the impeachment or the articles of impeachment against Justice Janen. And you, by the Constitution, shall preside over the impeachment proceeding. Article 43 gives you the authority to preside as the Chief Justice, but the question is, what happens if the Chief Justice is conflicted? And the exception to Article 43 that you shall preside, that our colleague said that is your constitutional right, is in Article 90 of the Constitution of Liberia. What does the article say in the Constitution of Liberia? Let me read it, Your Honor. Chapter 11, Article 90A. It says, no person, whether elected or appointed to any public office, shall engage in any other activity which shall be against public policy or constitute conflict of interest. That is the Constitution. My colleagues here said that because even if you are conflicted, there is no need for you to recuse yourself because the Article 43 provides for that. But 90 says that you shall not engage in a proceeding in which you are conflicted. Secondly, Your Honor, circumstance case, the petitioner alleged that Justice Janet manipulated the bench of the Supreme Court, coerced them, manipulated the bench to write and sign this opinion or judgment. Your Honor, I want to ask a rhetorical question, if you can permit. Assuming without admitting that you desire to preside over this matter, is it not possible that either any of the justices who signed this judgment could be subpoenaed to testify in the proceeding? Of course. Because it is the subject of an allegation contained in the petition for impeachment. That is why, Your Honor, you cannot preside. Your Honor, you have reason to grant our motion for recusal because it's simple. The respondent had admitted, and under the law of admission, if you fail to traverse a count in a petition, that failure constitutes an admission of the averment contained in the petition. What did the respondent say in count 7 of their returns to the motion for recusal? This is what the respondent said, Your Honor. They agree with us that there is a legal ground for the recusal, and they spell out the grounds. And you articulated those grounds in the case Justice Kabina and Janet versus the Honorable House of Representatives, represented by the Speaker, Honorable Buffers Chambers. But this is what they say in count 7, Your Honor. Respondent also submits that the grounds for recusal by a judge under our civil procedure law dictate that the judge must have either heard or presided over the merits of the case, made a determination thereto, or formed a previous opinion touching the depth and character of the case on its merits, and by presiding again at another stage of the same involving the same parties, the same issues, and applying the same rules and procedure. That is what they said. This is admission. It means that indeed the motion for recusal should be granted by you. Not by the basis of sentiment, but the law. What did you say, Your Honor? In the case Justice Kabina M. Janet, this is what you said, Your Honor. You said the only reason that a judge, but first and foremost, when the petition for prohibition was filed before the Honorable the Supreme Court. And when I made a submission before you, the full bench, for the recusal of Justice Nangwe, that at the time the articles of impeachment were being prepared and the communication had been made to the Senate by the representatives that they are preparing the articles of impeachment of the respondent, he was a member of the Senate. You read and denied that submission and made the following rule, which was an extension of the laws cited here, re-emphasizing the court's opinion, speaking through you. And you said, the only time and the reason that a justice of the Supreme Court can be recused from a matter before the court is if he or she has a relative that is involved, or if the justice is on record to have made a judgment or taken a decision or given an opinion on the matter, the justice can be recused. Precedent, the doctrine of stare decisis. When you said that, it became an extension of the precedence of the Supreme Court's opinion. And it serves today as the basis for judicial review in the judicial history of this country. And that is why, Your Honor, that you have to recuse yourself from these proceedings. But this is what you said. Let me read it.
Counselor.
Yes, Your Honor. Thank you, Your Honor. By the standards set by the Honorable Supreme Court, this is what you said, Your Honor. A justice is required to recuse himself or herself when that case is brought before the Supreme Court, or a justice is required to recuse himself from the case his relative is involved, or where the justice is on record to have taken a position with respect to a particular case.
Okay, then my question is it a law in this country that you know that when a case is brought to the Supreme Court, it can either be decided on a merit or it can be decided on technical ground? Do you know that?
That's correct. I'm aware of that, Your Honor.
Okay, then. Was the Annie Constance case decided on its merit?
Your Honor, it was decided based on the failure to perfect an appeal.
Correct.
And a decision was
Correct.
taken on the basis of that.
Wait now. So, the case came to the Supreme Court. There was a motion to dismiss filed by the winning party at the lower court. For reasons that the losing party, who happens to be in this case, Annie Constance, did not file an appeal bond and did not file or serve and file a notice of conclusion of the appeal. In that case, where a party has failed to perfect an appeal, do you know as a lawyer whether the court can open the case file and decide the case on its merit?
Yes, Your Honor.
You do?
Yes.
All right. Is it not a statute in this jurisdiction that when a party fails to perfect an appeal, the case file cannot open, and the failure of one of the 4 grounds listed under the statute is a ground for dismissal of the appeal?
That is correct.
So then, will you say that this Chief Justice decided the merit and demerit of the case, the Annie Constance case?
Your Honor, it is not the matter of merit or demerit. It is the issue of judgment given by the Supreme Court, which the Chief Justice affixed his signature, relying on the law. And this is what he said.
There?
This is what he said, Your Honor.
No. You have the judgment there?
Correct.
Please read the judgment.
Let me read the judgment, Your Honor. Thank you. When the case was called for hearing, Counsellor Cooper W. Cry of Heron's law firm appeared for the movement. No lawyer appeared for the respondents. Pursuant to statute and revised rules of the Supreme Court, that motions be heard and disposed of before the main case, except where the court on its own or upon the request of the parties to consolidate both the motion to dismiss and the main case. The motion to dismiss the respondent's appeal was called on December 1, 2015. Counsellor Lawrence Yekula of Liberty Law Firm appeared for the respondents and made a submission on the record of the court, requesting continuance for a period of 1 month to enable the parties amicably resolve the matter between them without further litigation. In response to this submission, the movement's lawyer, Counsellor Cooper, interposed no objection. The court granted Counsellor Yekula's submission for continuance, but the proviso that if the parties fail to file a statement of voluntary withdrawal within the period of 1 month, the court will proceed with the case and make a determination, underscore, Your Honor. The court observes that 10 months thereafter, that is on October 24, 2016, when the case was again assigned and called for hearing, the records not only show the absence of any evidence of a resolution of the matter, but also that no notice of voluntary withdrawal had been filed notifying the court that the matter had been amicably settled. Also on the said day of October 24, 2016, lawyer or lawyers representing the respondents did not appear for the hearing. The absence of the respondent's lawyers prompted the court to ascertain from the clerk whether or not the respondent's lawyers or lawyer were served with the notice of assignment, to which the clerk responded in the affirmative. Therefore, pursuant to the revised rules of the Supreme Court, Article 4, Part 6C, the hearing of the motion was ordered proceeded with, and the movement's lawyer proceeded with his side of the argument. The court sustained an argument. The revised rules of the Supreme Court provide as follows. If a party appears and the other party does not appear, but files a brief, the court will proceed to hear the argument of the party appearing and render its decision on the basis of the briefs filed and the argument of the party appearing. If one party appears and the non-appearing party has not filed a brief, no appearing counsel shall be given 48 hours. Non-appearing counsels shall be given 48 hours to file a brief and appear for hearing of the case. And the party shall be simultaneously informed of the non-appearance of counsel and the postponement of the hearing for 48 hours. If, when the case is called again for hearing, the party or counsel fails to appear or file a brief, the court shall proceed to hear the argument of the appearing party and rule thereon. Revised rules of the Supreme Court, Article 4, Part 6C. Accordingly, in presenting his argument, the movement's lawyer have read that while the respondents have filed their bail of exception, they took no further steps to perfect their appeal. Hence, this failure deprived the Supreme Court of jurisdiction to hear the case on its merits. A review of the records showed that on April 9, 2013, the assigned circuit judge of the 6th Judicial Circuit Court, Montserrat County, sitting in its March 10, AD 2013, entered final judgment in favor of the movement. The respondents noted their exceptions, announced an appeal therefrom, and on April 19, 2013, filed their bail of exceptions. The records also show, however, that this was the only step taken by the respondents in the process of effecting their appeal to this court, thus lacking in the filing of an appeal bond and the filing and service of the notice of completion of appeal. The other remaining mandatory steps. On October 8, 2013, almost 6 months thereafter, the movement obtained a clerk certificate from the 6th Judicial Circuit Court, Montserrat County, which indicated that other than the filing of the bail of exceptions, the respondents had taken no further steps to perfect their appeal. Given the fact that the filing of the bail of exception ipso facto divested the trial court of jurisdiction over this case, and that in such a case, the statute provides that a motion for the dismissal of the appeal shall be filed before the Supreme Court, the movement. On December 2, 2013, filed a motion to dismiss the appeal before the Supreme Court sitting in its October 10, AD 2013. The court, having reviewed the averments in the motion to dismiss, and finding that same is irrefutably in consonance with the applicable laws, it is hereby that the motion to dismiss, this is the judgment, Your Honor, that the motion to dismiss the appeal be and seem is hereby granted, and the appeal is dismissed. The clerk of this court is ordered to send a mandate to the 6th Judicial Circuit Court, Montserrat County, mandating the judge presiding therein to resume jurisdiction over the case and give effect to this judgment. It is hereby so ordered. Giving on our hands and the seal of the Supreme Court, Francis S. Corpus, Sr., Chief Justice of the Supreme Court.
Thank you. To which I attached my signature.
That's correct, Your Honor.
The contention in the bill of impeachment is that Mr. Justice Johnny purchased a piece of property in the wrong manner, that he paid little money for that amount of money, property, that he purchased from the wrong person. Matter of fact, the allegation is that the purported administrator of the estate was supposed to be 4 years old at the time the letters of administration were given to that person. What you have read, did it say that any of these points that are raised in the bill of impeachment, the Supreme Court passed on those issues?
Your Honor, articles of impeachment against Associate Justice Kabina M. Janet is the case that Justice Janet, in deciding the bench of the Supreme Court, in deciding that matter, manipulated the full bench to rule in his favor.
Correct. That is what the House of Representatives has said.
That is within the articles of impeachment.
Correct.
It serves as one of the abridgments contained in the impeachment.
How does it conflict my position and the position of the Associate Justice?
Because you made a judgment in the Constance case.
Yes.
And then you hear the motion for dismissal of appeal.
I want this because this may be, if you give me all of the indicators and so forth, maybe, I can. Conflict of interest, I ask you, what is it? In this case, Justice Janet has brought a matter to court to say there was no perfection of the appeal. And under Liberian law, you cannot open a case file to look into the case once you determine that there has been no perfection of appeal. As you correctly read, articulated the points that the members of the Supreme Court took into consideration, there was no issue as to the sale of the property, no issue concerning who the administrator was. These were not issues that this Chief Justice passed upon, neither did the other Associate Justices pass on them. So the merit of the case was never decided by the Supreme Court. Now, are you saying that the Supreme Court decided a case in favor of Justice Janet and his interest conflicts with the interest of the members of the Supreme Court who decided the
No,
case?
that's not what I'm saying. That is what they said, Your Honor. And you and him have been involved as one of
So
the
then,
signatories
Counselor,
making the decision.
do you have the standing to say what you are saying? Shouldn't it be the House of Representatives that is raising that issue?
Your Honor,
Or the other side?
Your Honor, it is an old-age tradition of our practice in this country that conflict of interest, the judge must be free of all interest involved within the particular matter. Okay?
Okay, Councillor.
The
next
motion,
question, perhaps.
the motion terminated the matter.
Councillor, will you yield when I ask? The question I want to ask is it a conflict of interest to follow the law as laid down by the statute governing appeal? Because you will agree that when you fail to file your bond, you fail to serve the notice of completion of appeal, it is a ground for dismissal of appeal without going into the merit and demerit of the case. My question then is it conflict of interest for the Supreme Court to follow the law as laid down in the statute?
An admission to what we have just said.
I am admitting.
No, it's an admission of our motion because, Your Honor, you follow the law in making the decision.
So then, how does it conflict with the interest of
Good,
Mr.
Your Honor.
Justice Janet?
It is that same in particular case. They are saying when you were following the law in making the decision, you have been manipulated.
Is it not your position at this place now to tell them that this could not be conflict of interest? Is it not what you're here to tell the senators at the point so that you can tell them it cannot be?
Your Honor, our argument here is that one of the counts in the abridgments in the petition for impeachment alleged that when you use the law to rule at the level of the Supreme Court, on their same case, they said that the respondent coerced and manipulated the Supreme Court bench that is the subject of these proceedings. And on the basis of the if we are to proceed, you are also conflicted because the decision taken by the Supreme Court is being questioned by the same managers who are saying that that decision that the court took in the constant case, Justice Janet had manipulated the bank. It's not important that even are they not thinking, or Your Honor, is the court also not considering that we can subpoena the Chief Justice and all associate justices of the Supreme Court that signed this ruling to testify if we are to proceed in the impeachment proceeding? They will be conflicted. Because we can call you to testify that you were not manipulated by Justice Janet. That is where you are conflicted, Your Honor. That is where you are conflicted. And we can proceed with this matter. And Your Honor, there are long-standing traditions that the Supreme Court have, over the years, have been the custodian when it comes to the neutrality and the impartiality of the proceeding and the position of a judge. We are not saying that indeed at the level of the Supreme Court you were manipulated. They say it. And because they said that, you can be and you are a prospective and possible witness, Your Honor. Because at the trial, I am prepared, Your Honor, to subpoena. Assuming if we have to proceed. But Your Honor, it's important that you don't have and you recuse yourself of this matter. Another satisfaction under the law that supports you in there is Article 90 of the Constitution, Chapter 9. It says an admission to what we have just said.
I am admitting.
No, it's an admission of our motion because, Your Honor, you follow the law in making the decision.
So then, how does it conflict with the interest of
Good,
Mr.
Your Honor.
Justice Janet?
It is that same in particular case. They are saying when you were following the law in making the decision, you have been manipulated.
Is it not your position at this place now to tell them that this will not be conflict of interest? Is it not what you're here to tell the senators at the point so that you can tell them it cannot be?
Your Honor, our argument here is that one of the counts in the arraignments in the petition for impeachment alleges that when you use the law to rule at the level of the Supreme Court on this same case, they said that the respondent coerced and manipulated the Supreme Court bench that is the subject of these proceedings. And on the basis of the if we are to proceed, you are also conflicted because the decision taken by the Supreme Court is being questioned by the same managers who are saying that that decision that the court took in the constant case, Justice Janet had manipulated the bench. It's not important that even are they not thinking, or Your Honor, is the court also not considering that we can subpoena the Chief Justice and all associate justices of the Supreme Court that signed this ruling to testify if we are to proceed in the impeachment proceeding? They will be conflicted. Because we can call you to testify that you were not manipulated by Justice Janet. That is where you are conflicted, Your Honor. That is where you are conflicted. And we can proceed with this matter. And Your Honor, there are long-standing traditions that the Supreme Court have, over the years, have been the custodian when it comes to the neutrality and the impartiality of the proceeding and the position of a judge. We are not saying that indeed at the level of the Supreme Court you were manipulated. They say it. And because they said that, you can be and you are a prospective and possible witness, Your Honor. Because at the trial, I am prepared, Your Honor, to subpoena. Assuming if we have to proceed. But Your Honor, it's important that you don't have and you recuse yourself of this matter. Another satisfaction under the law that supports you in there is Article 90 of the Constitution, Chapter 9. It says that the court or any official, appointed official, shall not engage in a process that will be on conflict of interest. You have also been accused in the petition, Your Honor, that you have been manipulated by the petitioner.
Yeah, forget what it. Let them bring me here.
Okay, but that's what I'm saying. That's what I'm saying. Before I take my seat, I will give you the reasons why you should recuse yourself from these proceedings. One, told people, we told the court, when we went to the Supreme Court, and we told you over and again, that this is not about Justice Janet. This is what they say, Your Honor, and I will read the account. Let's look at count 8 and 9. They travelers this petition. They travelers the petition. But let me just read it. That is what the manager said. Count 8 of their returns to our motion for recusal. Respondent submits that because this is not a judicial proceeding, but rather a legislative impeachment trial, with all of the Senate Standing Rule 63 and other applicable rules of the Senate, the Chief Justice presiding, inarguably, has no such power to amend, reverse, or modify any conclusion reached. Being reached in this matter by the senator sitting as trial of fact. The Chief Justice lacks the legal authority to set aside the verdict of the senators and grant a motion.
Councillor,
Yes, Your Honor.
the motion for recusal is directed.
Pardon me, Your Honor?
You think they can represent me adequately?
Well, they can represent you.
No.
The next thing, Your Honor, count 15. That as to count 8, 9, and 10 of the motion, respondent also incorporates count 4 of its resistance and says the reason provided for seeking the recusal of the respondent Chief Justice are unattainable in legislative impeachment proceeding, and therefore should be denied and dismissed. On ground that the basis for the impeachment of the movement of the House of Representatives is that there exists a collusion between and amongst Annie Constant's lawyers and movement Kabina Janet, the lawyer, on one hand, and among between movement Kabina Janet, his lawyer, and that Annie Constant's lawyer. All these lawyers are from Nimba County, with Kabina Janet sitting and actively prosecuting an injunction case as plaintiff party in the civil law court. They travelers this case. So this is not about a trial. This is about what? Tribalism. That's what they're insinuating here. Let me go to count 16. Movement respondent says the Chief Justice cannot and will not recuse himself from this legislative impeachment trial for the fact that the collusion between and among the lawyers with Kabina Janet at the apex center of this exercise paved the way for Annie Constant lawyers to absent themselves from court during the rendition of the purported default judgment in favor of Associate Justice Kabina Janet in the court below. And although Annie Constant lawyer later filed a bail of exception, they did not complete the statutory appeal, and therefore the matter was not heard and determined on its merits. That, further to count 16 above, respondent says even though Annie Constant lawyer had defaulted on satisfying the appeal process, they acknowledge it, as required by law, which you said, they however appear at the Supreme Court at the call of the case at a later date, and during representation, prayed the Honorable Supreme Court to give them time to find an amicable solution to request and duly granted, and the request was duly granted. Again, all the lawyers involved in the matter in the Supreme Court are from Nimba County, including Associate Justice Janet, and demonstrating a sense of camaraderie before the Supreme Court. No objection of the resistance was made by Justice Janet, lawyer, to the submission of Annie Constant's law. You see how frivolous they have become? So the entire foundation of the articles of impeachment have not been on the substance of the allegation or a violation of the law, but it has been on tribal sentiment. Your Honor,
Councillor,
there is a reason why you should recuse yourself and this
Councillor.
guilt. Yeah.
let's say that I should recuse myself. The recusal is directed straight to me. I am the one that you see I have conflicted myself, and therefore I should leave the case because I will not be fair to the movement. I will not be fair to the movement. That is what you have stated there. I keep asking you, how will I not be fair to the movement when my decision that we should talk about is not against the movement, but in his favor? How does his interest and mine clash?
Your precedent, the Justice Daniel case in November is that once the counsel or the justice is involved in the matter, you don't have to be in his interest or against the interest, but you have made a determination on the matter, and that matter is the subject of the impeachment trial, Your Honor.
Okay. Question. Let's assume that I recuse myself based on the eloquent presentation that you made. As a lawyer, I'm seeking advice. Who will preside?
Your Honor, that is not our business. Because, Your Honor, the Constitution of Liberia did not contemplate, the Constitution of Liberia, Article 43, did not contemplate in the event or in the case of incapacity of the Chief Justice who shall be presiding, who shall preside. And because the Constitution did not contemplate who interprets it.
So that means there is no statement of a deputy chief justice or assistant chief justice.
The Constitution.
Will you wait?
Okay.
When you're talking, I can listen to you.
Thank you. Thank you.
There is no provision for line of succession like the presidency when the president is incapacitated or cannot, then this person, then that person, then that person. It's not stated in the Constitution.
Correct.
So then, you write that I should recuse myself. Assuming I do, then what?
Your case here is you should recuse yourself.
Okay.
The intent of the Freemasons were never contemplated on the basis of recusal in the case where the Chief Justice is conflicted.
Then we'll go to the drawing board, and that's all.
And that would the legislature. And that would the Liberian people to go for a referendum. But in the absence of that, Your Honor, the law says when you are conflicted, under Article 90, you cannot preside, Your Honor. And that is the law. This is why I say, Your Honor, that there is a need for Your Honor to recuse yourself from these proceedings for the following reasons before I take my seat. One, that the recusal is provided for by law. The Constitution is clear. For the three, Article 90 says when you are in conflict. Two, you are conflicted, Your Honor. You are on record in the constant phase to sign an opinion. And three is to save the sanctuary and the dignity of the Supreme Court. Thank you. And so we'll close on the open.
A verified
Councilor, you go to the right. Use the mic.
Thank you, Your Honor. The Honorable House of Representatives responding in this proceeding has filed a verified legal memorandum containing all of the law citations, but for the sole purpose and the procedure adopted, we will just cite a few of them. And let the record reflect that Senate Rule 63 controls this impeachment trial. So Senate Rule 63, subparagraph 8, subparagraph 12 as amended, Article 43 of the 1986 Constitution, the principle of best evidence and relevance found on Chapter 25, Section 25.6 and 25.4 of the Civil Procedure Law. The case is Honor Kabina Mohammed Janet versus the Honorable House of Representatives. 6. Judicial Canon 25, Article 90A, Count 3 of the motions, moving motion, and Article 91 of the 1986 Constitution. Your Honor, we dissected moving motion into two parts. The first part we want to deal with is the factual issue and then the legal issues. We said the motion has no legal basis, has both no factual and legal basis. Factually, if you listen to the narratives presented here, you will see that the facts are not analogous to all of the issues. For example, in the case, His Honor Kabina Mohammed Janet versus the Honorable House of Representatives. Our police want you to recuse yourself and presented a fact, but yet what? The ruling from the Supreme Court said, which be presided over. A justice, and it's quoted in part, a justice is required to recuse himself when the case that is brought before the Supreme Court, or justice is required to recuse himself or herself from a case of his relative is involved, or where the justice is on record to have taken a position with respect to a particular case. This case, Your Honor, factually refers to the Supreme Court. Everything is before the Supreme Court in terms of location. We're talking about the venue. When I started on a factual basis, I said this trial is governed by Rule 63. This is a legislative impeachment proceeding at the Honorable Liberian Senate. So you are not sitting, you are sitting as presiding officer. You are sitting as presiding officer. The one they refer to, you are sitting as Chief Justice over a judicial proceeding. There are two separate and distinct facts. One may then be tempted to ask, Your Honor, is there a judicial proceeding in which a justice is presiding, or a legislative impeachment proceeding? Yeah.
What you should be, as they say, I have committed a conflict of interest.
Okay, Your Honor, let me, no, you have not. And your authority for presiding is Article 43 of the 1986 Constitution. Your Honor, there is nowhere in Article 43 where the function duly assigned to you should be referred to another party. That will amount to treason. Your Honor, that will amount to treason. Were you to do that, it formed the basis for the impeachment against you. And let me tell you what is treason. Article 75(5) of the 1986 Constitution states, and it's part of our brief, our legal memorandum, any other act that undermines the Constitution, abrogating, attempting to abrogate, subverting, attempting to subvert, and any other act that tends to undermine the Constitution. If you abdicate that responsibilities assigned to you by the Constitution, you are committed treason and a ground for impeachment. You have no authority. No authority, Your Honor. Now, if you read our legal memorandum, we cited, for instance, a requirement taken from what counselors, lawyers who take the oath of office before the Supreme Court should do. What I say, a counselor will not counsel and maintain any suit or proceeding which shall appear to him or me to be unjust, nor any defense except such are believed to be honestly debatable under the laws of the land. How can anybody, Justice Kabina Mohammed Janet, an interpreter of the law?
Wait, Counselor.
Yeah.
Kabina M. Janet.
Yeah, it's Mohammed.
For the purpose of this trial?
Yeah, because, Your Honor, in a trial, not because for the purpose of the trial, Your Honor, in a trial that has this kind of feature, you have to call the full name so that the person knows that you're referring to him, because there have been so many Kabina Janet. So I keep saying, His Honor, Justice Kabina Mohammed Janet, Associate Justice of the Supreme Court, under no given condition can compel file an application before you, Your Honor, indicating that you should violate the Constitution. Now, what is the strategy, Your Honor? What is their strategy? They have not cited or provided any legal basis why you should recuse yourself. They just said, oh, you had a case. You had any constant case. The only constant case, this rule that was applied in the only constant case is under the civil procedure law is Article 51 of the civil procedure 51.4. It governs the appeal process. You can look at it, Your Honor.
You have it there?
Your Honor, we have it here, 51.4.
Read it.
Bring it. I read, Your Honor. Requirement for completion of appeal. The following acts shall be necessary for the completion of appeal: announcement of the taking of appeal, filing of the bill of exceptions, filing of an appeal bond, service and filing of notice of completion of appeal. Failure to comply with any of these requirements within the time allotted by statute shall be ground for dismissal of the appeal.
Now, question that I asked them.
Yeah.
When the party fails to abide by any of these grounds,
Yeah.
can the Supreme Court decide the merits and demerits of the case looking into what was decided at the lower court?
Absolutely no, Your Honor. No. And Your Honor, I just wanted to add to that. A motion before a court is an ancillary action growing out of the main suit. And the basis of the motion is what? It contests purely few issues either on the basis of jurisdiction, either on the basis of default. What was decided was a default on the procedural error, not on the merit of the case. And so, Your Honor, you have committed no reversible error and you cannot recuse yourself. Were you to do that, you will commit treason and the ground for impeachment against you.
Can't I leave the treason and the ground for impeachment? I'm not concerned about that. I'm not afraid of
Your
that.
Honor, the motion as filed is more like a Trojan horse. And we say it's a Trojan horse because it is filed under the pretext of fair play, accountability, and transparency. But, Your Honor, if you don't go to court without having an answer and say, I'm going to court, when you ask him, if I recuse myself, who will preside? He say, I don't know. Your Honor, at this level, we come to this proceeding. You want the justice presiding, as presiding officer, to recuse himself, but you still don't have any law or any ground. You have shown no ground. Your Honor, the motion for recusal, and as I indicated, they quoted the count that we referred to. In one of the counts, account 8, we said, there are grounds for which a judge may recuse himself if he made a previous decision in a matter. And then at another stage, he transcends to another stage that the same party, the same issue is brought before him. It is obvious that when he chooses to make a decision based on what a motion for new trial, because the motion for new trial will be challenging that the verdict as rendered is contrary to the evidence due. In that case, the judge's previous decision will haunt them. In your case, Your Honor, in this proceeding, you have no such power. All you are required to do, you are simply a referee. As a referee, that's not your responsibility, Your Honor, to play number 9 and score. You only watch the game and apply the rules. You have no authority to amend. You have no authority to reverse. You have no authority to modify any judgment, any decision reached by the Honorable Librarian Senate. If the Honorable Librarian Senate says, this is it, Your Honor, your decision, 2 rule. Ensure the due process principle as provided for, the Supreme Court has empowered on that. In fact, Librarian Law Report 423, the Wallow versus Wallow case, which you have very much spoken with, apply Article 28 of the 1986 Constitution, and the due process principle requirement regime include what? That the defendant can either appear or file his answer or bring witnesses in his own name. He can testify, if he so desire, or he can cross-examine other witnesses and confront whoever witness the accusers will bring. That's all you're supposed to do. In this trial, you get no power to do what they think you will do. And the only rule you're going to apply is that you are a referee, and you strongly indicated that. This morning you said, I will not allow distraction. Your Honor, that was part of your power. Ensuring orderliness in this place, ensuring that there is orderliness is part of the responsibility. But as to the final decision to determine,
You can't. So you don't even have the power, Your Honor, to recuse yourself because the Constitution imposes upon you that sovereign responsibility. Now, aside Article 91, there are requirements, Your Honor, on our law. If a Liberian citizen disagree with a law, there are two ways. Your Honor, you can either go by what? Invoke Article 91 by securing not less than 10,000 signatures, or go to the legislature to do a general resolution that will cause a national referendum. Article 91. Justice Kabine Mohammed Jane fully occurring with the law sat there, and then nothing, he came to court and want to use a motion to subvert the Constitution. Your Honor, they want us to entertain that. He wants to use a motion to cause a serious crisis, a serious constitutional crisis, that will even spark people to carry out citizen arrest for you to recuse yourself. That's the extent to which the sovereignty and the dignity of our Constitution is being threatened. Your Honor. Your Honor, we want to proceed to the third issue. The Chief Justice of this Republic is constitutionally mandated to preside over impeachment proceedings. Now, there is nowhere where there's a provision or a condition for a substitute. I thought, and we should have been, that if they raise the issue of mental or physical capacity, it will some to a large extent make a sense, or rely upon any provision of the Rule 63. In this case, they decided to engage in fishing expedition. Recuse yourself. When you ask them, when I recuse myself, who will preside? I don't know. Oh, you come to this proceeding, all your motion is based on nothing. Now, Your Honor, the other issue you want to raise is that they said, first and foremost, the oversight there, I want to bring that to your attention. Maybe when somebody will bring the issue up. They said they read a summons that has been issued out of this proceeding.
That's not an issue.
It's part of two passing on it.
We are not raising it now.
All right, Your Honor. Okay.
They came here.
Okay. All right, Your Honor, we leave it. Basically, this motion should not have been entertained in the first place. But we have to give them the freedom so at least they can be heard. The Annie Constant case was never determined on the merit. It was determined on the basis of a motion, and the motion dealt with procedural default as to who owned the land, as to how the land was bought, as to how it was bought, who bought it. That's not an issue. The issue that went to the House of Representatives is the collusion between and amongst Justice Jane, Justice Kabine Mohammed Jane, Associate Justice of the Honorable Supreme Court, his lawyers, the lawyers of Annie Constant, that led to a collusion that paved the way for them to absent themselves from court. That is a criminal offense that the House investigated and found a probable cause that is before here. It is not an action of ejectment case. What was in the civil law court was an action of ejectment case in a civil proceeding, and the one that went to the Supreme Court was a motion growing out of the ejectment action. In this case, a collusion that bordered on criminality that has to do with official misconduct of an associate justice of our highest court in the land. He talked about, they said the system was manipulated. Where's the evidence? We said it was a collusion between and amongst. Give us the opportunity, that will produce the evidence. You can raise it for all. We have the standing, the legal capacity to raise that, and we are the ones to prosecute that. Now you can be the one. You can be the one to determine for us. So, Your Honor, the plain language of Article 43, there is no exception to it. And where there is no exception, the law stays as is. If Justice Jane Justice Kabina Mohammed Jane wants to see a constitutional amendment of Article 43 that devolves upon you the authority to preside over impeachment proceeding after you should have been impeached, let it go and secure fewer than 10,000 signatures. But until then, that is the law controlling, supported by Rule 63 of the Senate Rule. And what is even more striking, Your Honor, and I thought my colleague would have had an alternative response, was the most important question you asked. Assuming, and Your Honor, when you say assuming, I held my breath because I was listening to see. And thank you, Your Honor, it was based on assumption because constitutionally you are without any authority to violate the Constitution in plain view of the Liberian people. You can't do it. And that's what they're asking you to do. When I took the oath at the Supreme Court, I was warned that I should never ever try to enforce or influence any judge or justice to try to make them to make mistakes. If I were across the road, Your Honor, I will ask you to hold my friend in contempt for asking this court in plain view of the word that you, presiding by dictate of the Constitutional Article 43, to violate Article 43, abdicate your constitutional responsibility, and then create a serious pandemonium in the state. Your Honor, were you to do that, there will be chaos. There will be a serious constitutional crisis. Oh, granted, Your Honor. So, in that way, it will suggest to me that our colleagues are contemplating that Justice Janet hopefully may preserve, because as number two, if you abdicate your position of responsibility, he obviously will preserve. And when he preserves, what happens? It will amount to having, for instance, there's an excuse, having an armed robber presiding over a own trial. Can you imagine?
Counselor.
I'm saying this is an assumption.
Wait. What's your language?
Yeah, I was just saying this is an assumption.
Justice Janet is not.
Your Honor, are you?
If you do that again.
Are you, Your Honor, are you? Your Honor? So, Your Honor, I want to close on the opening and allow my colleagues. I'm going to close. Let me close with a few remarks. Our country is at a crossroad. This motion has no legal basis. And this court should not, this proceeding, should understand that you sit and presiding over a legislative impeachment proceeding, not a judicial proceeding. The rule governing this process is Rule 63. They have demonstrated no evidence in clear and unambiguous terms which provision of Rule 63 you violated that will form the basis for your recusal. That one. The second issue that I want to say, Your Honor, under no condition can you, duly empowered by the Liberian Constitution, under Article 43, which says the Chief Justice shall preside. Then you come to court and somebody file and say you are conflicted without showing any evidence of your conflict, then you say you walk away from your responsibility. That will amount to treason and it falls under Article 75, subparagraph 5, which says, and I quote, Your Honor, any act that abrogates or attempt to abrogate, subverts, or attempt to subvert, or any other means undermining the Constitution constitute treason. It will be a ground for the impeachment. And we don't want to have that serious constitutional crisis. The third issue I want to raise, Your Honor, the motion for recusal is directed at you. It's directed at you. We are co-responding. We say you cannot recuse yourself because they have provided no legal basis, legal or factual basis why you should recuse himself. The process you presided over across the road is called a judicial proceeding. The process you presiding over here is called a legislative proceeding. Under the new arrangement, you are called presiding officer. There, you call Chief Justice. The only thing you come out here that you bring along with you is the title. But the rules governing the procedure here are the rules of procedure and evidence of the Honorable Liberian Senate as provided for under Rule 63. So why is true? Why is true intermittently will revert to the judicial aspect, but the rule controlling the standing Rule 63 that controls the entire proceeding. And for anyone to come before you, Your Honor, and ask for recusal, they must list and show in clear and unambiguous terms which provision of the rule you violated. When that is not done, Your Honor, you certainly cannot abdicate your constitutional responsibility as provided for under Article 43. Finally, Your Honor, the Supreme Court under Article 2 has 4 powers. The power to review, the power to interpret, the power to declare, and when it does that, it becomes supreme. 4. Under Article 66, which is the finality doctrine, every matter that goes over the Supreme Court has final arbiter authority over factual issue, constitutional issue, appellate remedial issue, and all issues bordering on motion. The decision made in the Annie-Constant case was purely a motion dealing with a procedural default. That decision was final. It didn't touch the depth and character of the merit of the case. And so it's not applicable before this proceeding. For this proceeding is not entertaining an ejectment action or a motion growing out of an ejectment action. What the proceeding is all about, it entertains an official misconduct, abuse of power, theft of property, manipulation, collusion are all part of the proceeding. Your Honor, we need protection from this side. We see some distraction. So that is separate and distinct. And having said that, Your Honor, we pray that the motion as far be denied, dismissed, and at no time did we, in any form, manner, or shape, trivialize this into a clever battle. We deny all in singular, all that our colleagues have said, and maintain that you cannot abandon the constitutional responsibility as devolved upon you under Article 43. And we submit, Your Honor.
May I please, Your Honor? Count 9 of the articles of impeachment as amended is what that has brought us here today. I look at it as being mysterious, and the lawyers in the Judiciary Committee of the House of Representatives did a disservice to the Supreme Court, knowing fully well that the Supreme Court apply the law in such matters, properly applied. But what did they say, Your Honor? In cases where an appeal is subject to dismissal due to gross negligence of an appellant's lawyer, the Supreme Court has traditionally heard the case on its merit and punished the lawyer for his negligence. That is not true. That is not true. There are 4 grounds for dismissal of an appeal. And they promulgated that statute, Your Honor. They promulgated it. And said when this happens, when one of these conditions is met in a case, you must dismiss it. And that is what you did. Then they went further. But for Madame Annie Yancey Constant appeal, the respondent, Associate Justice, manipulated the Supreme Court. There where you come in. There where you come in. If they say the Supreme Court, under your leadership, was manipulated, That is an attack on your reputation. On your reputation. So, how can you sit?
Dr. Momo,
Yes, Your Honor.
I understand what you say. Section 51.4 of the statute lists the grounds for dismissal of an action where the appeal was not perfected.
Yes, Your Honor.
1, 2, 3, 4. And it says under the failure to comply with any of these requirements within the time allowed by statute shall be the ground for dismissal of an appeal. This has always been applied, that's all.
That's true.
Also, in this case, the case file is never open to look in there in the belly of the case to find out what happened down there, what didn't happen there. That's all.
Your Honor, why it is true that the case file is not open, but the judgment of the lower court.
I haven't gotten to the judgment yet.
No, I say, well, it's open.
Yes. If you do not open the case file to find out what happened in the lower court, as the law says here, failure to comply with any of these grounds is a ground for dismissal, then how do you determine how the property was what? The amount that was paid? Counselor, if you want to object, you can come up here and argue here. Don't disturb me.
Sorry, Your Honor.
Okay. My question is, how can there be a conflict of interest
Your Honor,
when the merit was not even looked into? What we did was,
Your Honor, the issue is that you were manipulated.
correct, that's what they say.
So,
Do you agree?
I don't agree. But if you were manipulated, as they said, are you qualified to sit on a matter in which they have challenged your integrity, Your Honor?
After you and myself supposed to be on the same side. In relation to the decision that was made by the Supreme Court
Your Honor,
and the statement on the other side.
we are talking about the bill of impeachment. That's why we say it's mischievous. That's why we say it's mischievous.
Proceed, counsel.
So, Your Honor, if you say you were manipulated, is it not against public policy for you to sit on this matter? Because that's what Article 90 says. It is completely, even if you say it's not conflict of interest, but it is against public policy for you to sit on the matter in which you have been, in which you have, your integrity has been called into question. That's why we are saying they should have never, ever put it in. Because they had no basis of putting it there. But they have made it an issue. They have made it an issue. Your Honor, they argue that this is why a legislative proceeding. Your Honor, our Constitution is clear. No person shall be denied of life, liberty, privilege, property, except by a hearing judgment consistent with due process of law. Justice Daniel has what? The privilege to serve as associate justice. Before you deprive him of that privilege, it must be consistent with due process of law. That's why the Constitution provided that the legislature should prescribe the rules of impeachment proceeding consistent with what? Due process of law. for him to argue that the Senate amended Rule 63 governs this trial, I disagree. I disagree. And as you said in your opening statement, this trial will be governed by the Constitution, the statute, and law and other laws of the Republic of Liberia. I agree with you on that. He argued that Your Honor should not have entertained this motion in the first place. How can you say that? Justice Janet is entitled to be heard. He's entitled to be heard. His constitutional right to be heard. And he raised the issue of you being conflicted, and if your setting being contrary to public policy or against public policy, as provided for under Article 90A of the 1986 Constitution. They argued that the case, the constant case, was not decided on the merit. The case was not open and decided on the merit. Your Honor, while it is true that it was not open and decided on the merit, but the granting of the motion to dismiss the appeal concluded the rights of the parties and terminated the case forever. That is what that motion did. That is what was done in that case. Your Honor, he also argued that when Your Honor to recuse yourself, you will be committing a treasonable offense. How? How? They are the ones that brought the issue for which we are asking you to recuse yourself. There was no basis in mentioning in the articles of impeachment the constant case. I don't see the basis. So because they were being mischievous, this is what had got us here. This is what had got us here. He argued that the issue were criminal matters. So they're not relevant, Your Honor. I just want to counter them. They were criminal matter. The legislature has any right, especially the House of Representatives, to delve into criminal matters. They don't have. They have the authority to tell the people to pass into law the conduct that will be deemed criminal. And they have the right, and in that they provide the elements that will constitute a particular crime. But to say they can investigate criminal matters, no, Your Honor. That is purely left with the criminal justice system, in which they are not part. In which they are not part. Your Honor, we have our awareness. Our awareness were never traversed. They were never denied. So that means they are met. Because in a responsive pleading, you are required to advise those counts. So I see why you ask them. You ask Councillor Johnson whether they can adequately represent you. So, Your Honor, we don't need to waste this quota. We pray in the interest of justice that you recuse yourself and save the dignity of the Honorable the Supreme Court of Liberia, and respectfully submit.
The hearing of the motion, listen to the resistance. We will reserve ruling, and the ruling will be delivered tomorrow at the hour of 3 o'clock. 3 o'clock. Now, after that, then we'll see whether or not the proceedings will continue. So at this time, we'd like to adjourn and meet on tomorrow at the hour of 3 o'clock. Thank you. Also, the senators remain here to listen to the motion, even though we are explaining that, you didn't have to be here. I'm sure you have interest in the case. Thank you very much.
Yeah.